For joining us on the news, everyone, I am Nifemi Oguntoye. We'll begin at the National Assembly, where the Senate has now retained Section 60, subsection 3 of the Electoral Act Amendment Bill, leaving operational discretion to the Independent National Electoral Commission. The decision was taken at an emergency plenary session today. Tidesu Adeoye has more.
At an emergency plenary session on Tuesday, the Senate upheld Section 60, sub 3 of the Electoral Act Amendment Bill, affirming that the electronic transmission of election results remains subject to INEC's determination of the most appropriate method. Plenary proceedings were triggered by a motion from the Senate's Chief Whip, Tahir Mungunu, who sought to rescind the Chamber's earlier decision on the clause, citing public backlash. Senator Mungunu clarified that his intention was not to overturn the Senate's position, but to amend the wording from transfer to transmit.
Notes that upon careful examination of the bill, fresh issues have emerged in respect of Clause 60, sub 3, which requires further legislative consideration in order to ensure the conduct of smooth, transparent, and credible elections in Nigeria. And relying on the provisions of Orders 1B and 52.6 of the Senate Standing Orders 2023 as amended, accordingly resolves to rescind decision on Clause 60, sub 3 of the Electoral Act, repeal and enactment bill as previously passed, and recommit Clause 60, sub 3 to the Committee of the Whole for further reconsideration and passage. I so move.
The Senate adopted the amendment without vacating its earlier resolution. Under the provision passed, presiding officers are required to electronically transmit polling unit results to the IRF portal after Form EC8A has been manually signed and stamped and countersigned by party agents where available. Where electronic transmission fails due to communication challenges, the signed Form EC8A becomes the primary document for collation and declaration of results. Attempts by Ainaya Baribe to call for a division of votes were later withdrawn amidst overwhelming support from the majority.
Any senator may challenge the opinion of the president or the chairman by claiming a division. Mr. President, I claim a division. In respect of? We need to vote individually. I wish to withdraw my motion.
The Senate President insists that lawmakers seeking further changes may do so through substantive motions.
Provided that if the electronic transmission of the result fails, if it fails as a result of communication failure, in other words, maybe network or otherwise, and it becomes impossible to transmit the result electronically in Form EC8A, signed and stamped by the presiding officer, and or countersigned by the candidates or polling agents where available at the polling units. The Form EC8A shall in such a case be the primary source of collation and declaration of results. Those in support of the motion as enunciated by Senator Mungunu and seconded by Senator Bamoro say aye. Aye. And those again say nay. The ayes have it.
In a related development, the Senate reconstituted a 12-member conference committee to harmonize the Electoral Act, naming Simon Bako Lalong as chairman. Following the reconstitution of the conference committee and the adoption of votes and proceedings, the Electoral Act amendment advances to the harmonization stage between the Senate and the House of Representatives. Tidesu Adeoye, TVC News, Abuja.
Let's bring in lawyer Liborous Oshoma for more on this development. Mr. Oshoma, thanks for joining us on the news tonight. What does the Senate's decision to retain Section 60, subsection 3, leaving electronic transmission to INEC's discretion really mean? Does it strengthen or weaken the credibility of our elections?
First and foremost, I would say that this was the same position that we've had in 2023 election. The only difference is that now you have it stated in the Electoral Act that there shall be electronic transmission where possible, and then manual collation where electronic transmission is impossible. That has been INEC guideline, just that it is now part of the Electoral Act because the Supreme Court has said it was in the Electoral Act. So nothing really changed. But I can tell you that all of the back and forth is happening because of the failure of trust on the part of the people. The people don't trust their leaders because of the antecedent of the leaders consistently. Transparency in election and electoral processes is far from, the process is far from being transparent. And so because of that, even when you say that certainly in some areas, it might be impossible to transmit election results electronically. But as soon as you are able to access network, you should transmit those results. But all of this, we know because of the lack of trust, certainly this will not happen. So to answer your question directly, nothing has changed. It's not as if it has enhanced the credibility of the process. The people that manipulate the process are still there. I can tell you, remember, even in the INEC guideline in 2023 election that introduced electronic transmission, if you look at paragraph 93 of that guideline, it says that when it is impossible to transmit election result, electronically, that you shall resort to manual collation. So electronic transmission first, and then, when it is not possible, manual collation. So that's basically what the Senate had just adopted. But like I said, what is causing all of this brouhaha is lack of trust.
Deficit of trust. Indeed, which is very important, Mr. Oshoma, especially where the legitimacy of an election is concerned. We heard the Senate today saying that results must be electronically transmitted, but allows for Form EC8A to take precedence where technology fails. Now, I'm wondering if that means that at collation, INEC officials will look into IREV rather than looking at the EC8 forms. But let's talk about what this means for the tenability of the IREV results at the court, because the Supreme Court was a little bit definite about this in 2023.
Yeah, but before I quickly answer that to your question, let me say this quickly, that that section 60 subsection 3 that has just been introduced, it's also nebulous. It's because like section 305 of the Constitution that empowers the president to use extraordinary measures not defined, and the Supreme Court has said, since it is not defined, extraordinary measures can mean suspending a democratically elected government. In the same vein, this where electronic transmission is not possible, it's also not defined. What if this electronic transmission, the impossibility to transmit the election result electronically is as a result of human interference? What if I decide to create a glitch and make it impossible to transmit election results on the day of election? And so it is not defined. So even the umpire can frustrate the process and say, well, the law permits me to resort to manual. So when that happens, the IREV becomes, a mere paper tiger. But now coming to your question, before now, like I said, it was not part of our Electoral Act that transmission shall be done electronically. Now that it is part of the Electoral Act, so certainly the court is going to take cognizance of the fact that results are transmitted electronically where it is possible. So it is where it is not possible that the court will now take cognizance of the fact that, there are still manual collation. And that is the confusion also created by Section 137 of the same Electoral Act, where the court when the law talks about admissibility of documentary evidence, but that when the documentary evidence is not succinct enough or prove direct evidence of the irregularities, you resort to oral evidence. And so when that happens, it means that you're still going to be calling witness, polling unit by polling unit. So if there's failure of transmission electronically, Even though the IREV is there, you're still going to resort to Form EC8A. That's basically what is going to happen at the tribunal. So, but all said, now the law recognizes that there is an IREV that result can be transmitted to where possible. That's where the big problem is, where possible.
Interesting days ahead. The Senate has now inaugurated a 12-man committee that will harmonize with the Committee of the House of Representatives. Lawyer Liborous Oshoma, thank you for your insight.
My pleasure always.
But while Governor of Nasarawa